What I'd like now to talk about is how the Law of the Sea Convention helps us achieve those capabilities, and how not being a member actually hurts our ability to do those jobs. If there's an overarching aspect to all this, it's freedom of navigation. What the Navy brings to the table is the ability to go where the force is needed. And so the idea of freedom of navigation, the fact that we can go where we need to go, when we need to go, that's a key part of our national security strategy. And UNCLOS gives us that. A few examples: innocent passage, the ability for any of our ships to go within the territorial sea of another country without the need to provide notice, without the need to request permission, is key. Straight transit passage, when the Law of the Sea Convention was being negotiated, the part of the delegation dealing with Navy equities, their instructions were, if you don't come home with straight transit passage, you don't come home. This is the holy grail for us. If you look at a map of the world and you identify the international straits, the choke points of the world, if those coastal countries could close those straits, you would quickly see that there's simply no way that, even putting aside the effect on commerce, there's simply no way that our Navy could continue those 6 core capabilities. What we got out of UNCLOS was, in those strategic international straits, they can't be suspended. The coastal states simply cannot close them down. Same thing applies for archipelagic sea lanes passage, the ability to go through large archipelagos, particularly in the South Pacific, again, without having to ask permission or give notice. Non-discrimination between nuclear-powered or nuclear-armed ships and non-nuclear armed or powered ships. You can understand how that would be a key provision for the Navy, considering a number of our ships, particularly our carriers, that are nuclear-powered, our submarines, nuclear-powered and nuclear-armed. Military activities in the EEZ. The exclusive economic zone is the area from the coast out to a maximum of 200 miles. And what it does, it's a creature of the Law of the Sea Convention, gives the coastal state control over the resources of that area, namely the fish stocks. It doesn't give the state any further, the coastal state, any more authority than that. Again, if you picture the map of the world and drawing a 200-mile line around all the coastlines, you would see what a huge portion of the world would be excluded we would be excluded from as a Navy, unless we had UNCLOS giving us the right to go into that territorial sea, to exercise what we call high seas freedoms. And for us, high seas freedoms includes military activities. So there are some countries that will take issue with that. You may have seen in the news in the last year where we were doing military surveys and China objected because we were in their EEZ. Well, it's one thing if we didn't have any law to point to and simply said, well, we're going to do it. Well, you can understand how that could escalate. That's not the way we'd like to do business, to keep the issue contained. But being able to cite to the Law of the Sea to say, look, high seas freedoms apply in the EEZ. We're in the EEZ, and we're allowed to do this. We are on solid legal footing to do so. And finally, the Law of the Sea Convention affirms the sovereign immunity of our warships and our commercial and our government vessels, and that they are not subject to inspection, search, etc.